Hello everyone, in this video I will be discussing the administration of justice in Calcutta. So the administration of justice in Calcutta, it started from 1690 and it lasted till the Charter of 1726. Now starting with the historical background. So it so happened that in the year 1690 some Englishmen they landed at Sultanati, and this Sultanati it was located on the bank of the river Hooghly, and there they constructed a fortified factory named Fort William. So Sir Jeb Charnock laid the foundation of Fort William, which is at present Kolkata, on 24th August 1690. Now in 1698 the company succeeded in securing the zamindari rights of 3 villages. These 3 villages were Calcutta, Sultanati and Govindpur for an annual revenue of 1195 rupees from Prince Ajimur Shan, who was the grandson of Aurangzeb and also the Subedar of Bengal. By obtaining the zamindari of these 3 villages, the company now assumed the functions of a zamindar and also acquired the legal and constitutional status to exercise administrative jurisdiction over the native inhabitants residing in the territory. In 1699, Calcutta was declared as a presidency town, and thereby a president and council was appointed to administer the people living in the settlement. Now let's see the administration of judicial system that was going on before the advent of the East India Company in Bengal. So during the initial days of the Mughal Empire, the zamindars of Bengal collected land revenue and maintained law and order within their zamindari limits. Apart from these 2 functions, they enjoyed no significant judicial power. Apart from the zamindars, there were also the Qazi's court. This Qazi's court was established throughout the country and it decided civil and criminal cases. A Qazi was appointed in each sarkar or district, in each pargana, in each city and even in a large village. There were also the village panchayats, and this village panchayat could decide all kinds of cases except those pertaining to serious crimes. Appeals from the decisions of the panchayat lay to the Qazi of the Sarkar, and then from the Qazi of the Sarkar appeals lay to the Chief Qazi of the Subha. However, not much litigation came before the Qazis because of the existence of village panchayats and also because civil causes amongst the Hindus were decided by their own elders or Brahmins. Now with the disintegration of the Mughal Empire, the zamindars, taking advantage of this situation, they extended their jurisdictional power, and now the zamindars could administer justice in all cases, be it civil, criminal and revenue. For civil cases, the zamindar established a Kachari court. Appeals from their decisions lay to the Nawab courts at Murshidabad, but this was mostly in theory. In practice, not many appeals were actually taken. The zamindars could also award capital sentence, but this capital sentence it was subject to the confirmation of the Nawab's court at Murshidabad. The proceedings of the zamindar courts were very summary and unsatisfactory and were hardly impartial. Judgments were mostly discretionary. There was no definite body of law which they administered. They even did not maintain register of proceedings in their court. They used the judicial powers not impartially but in their own interest, not for justice but for oppression. Now coming to the Nawab's court. Theoretically, the highest criminal court was that of the Nawab, which was situated at Murshidabad. The Nawab, he was the head of the Nizamat, and as such he was responsible for maintaining law and order and also administering criminal justice. The highest civil court was that of the Diwan, who used to be the head of the Diwan and thus responsible for collection of land and revenue. Theoretically, the Nawab's court was a criminal court, but at times it could also decide matters relating to land and inheritance. So, there was always a confusion relating to jurisdiction between the courts of the Nawab's deputy and the Diwan's deputy. Thus, on the whole, the administration of justice was in a very poor shape in Bengal before the coming of the East India Company to Bengal. An important factor responsible for this grave injustice was the uncertainty of law. There was no regular system of law. Now, the judicial system at Calcutta. Now, after the arrival of the East India Company in Bengal, the company appointed an English member of the Governor's Council, and he was named as the collector. And so he was empowered to collect revenue and decide civil, criminal and revenue cases of the native inhabitants. The English collector maintained a Fojai court for the administration of criminal justice. The trials were held in a summary manner without the use of jury. The common modes of punishment that were awarded to the persons included that of whipping, imprisonment, banishment, fine, work on roads, etc. Thus, harsher modes of punishment were awarded to the native inhabitants. Death sentence could also be inflicted not by hanging but by whipping or lashing. The execution of death sentence was, however, subject to the confirmation by the President and Council of Bengal. As regards the offences committed by Englishmen, the collector could take cognizance of only petty crimes and minor wrongdoings committed by them, and in case of serious offences, such offences could be tried by the governor and council. So, the collector decided civil cases in his court called the Choudhary court. The cases were decided in a summary manner according to the custom and usages of the native inhabitants, and in their absence according to the principles of equity and good conscience. Appeal from these cases lay to the governor and council. He was also empowered to settle revenue cases and disputes relating to lands. Thus, as a whole, the judicial scheme introduced by the East India Company in Calcutta in 1700 AD had two distinct features. The first one was that the English collector could award death sentence which did not need the confirmation from the Mughal Nawab of Murshidabad, but rather it needed the approval of the governor and council of Calcutta. The second is that all the appeals from the collector's court lay to the governor and council at Calcutta and not to the Nawab's court at Murshidabad, as was the case with the native Jamindar's court. So, to sum up, it may be stated that the administration of justice in the settlements of East India Company before 1726 was executive oriented. There was no separation between the executive and the judiciary, and the executive enjoyed overriding powers to appoint or remove the judges. This system continued till 1727 and was replaced by a new system under the Charter of 1726 in common with the other presidency towns. With this we come to the end of today's topic. Hope you liked the video. Thank you.